So the next speaker is me, so I'm not going to introduce myself, but I'm going to speak to you today briefly about, give you an overview of procedural fairness as it occurs in workplace investigations, including when to provide a subject officer details of the allegation against them and some other practical tips. So this is aimed at those people who are either undertaking or overviewing a workplace investigation. So the scenario is that a complaint's been made about a staff member misbehaving in the workplace, and you're either responsible for undertaking or overseeing that investigation, or you may be the decision maker. So I'm hoping that this topic's familiar with a lot of you anyway, and you've probably seen references to it, but we thought it was a good opportunity to sort of collect it all in the one place at the one time. So what is procedural fairness? This will be an overview of what I'm going to discuss briefly today. What is procedural fairness in the context of a workplace investigation? What are the rules and the requirements? Some of the practical tips that the CCC has identified, and perhaps answering some of those questions that are often asked when an internal investigation is undertaken, and some handy resources. And yes, Marie, there'll be a plug of the Corruption in Focus document, you'll be pleased to know. So firstly, procedural fairness, and what is it? And you'll often see procedural fairness and natural justice being used, and really they're the same concept and often are used interchangeably. I'll just stick with procedural fairness. It's a common law duty imposed on decision makers to act fairly when making a decision under a statute where that decision will adversely affect an individual's rights, interests or legitimate expectations. So that's an administrative law principle well known in administrative law. But clearly, excuse me, a decision to investigate an allegation made against somebody in the workplace and then to decide to take disciplinary action, they are decisions that will can and will affect and adversely affect an individual's rights, interests or legitimate expectations. So procedural fairness is relevant. To distill what's been said in the common law, in the cases in Australia over the years, really it can be summarised in three main rules, and they're the rule against bias, the hearing rule and the evidence rule. And again, for those in the audience today who've been involved in internal investigations, you'd probably be familiar with these concepts. So just quickly summarising what those key rules entail. The rule against bias, quite obviously, is that the decision maker is free from actual and apparent bias. So not just actual bias, but apprehended or apparent bias as well. The decision maker doesn't prejudge the issue. They're impartial. They have no conflicts of interest, no material interest or personal association. So we think that applies not only, well, that it clearly applies to the decision maker, but it's also best practice for those principles to apply to the person who's appointed the investigator to investigate a workplace complaint. The importance of having, and this was picked up by Marie a moment ago, the importance of having an independent investigator, somebody who is not interested in the subject matter. They're not friends or mates or work colleagues with those that are under investigation or who have made the complaint or are likely to be witnesses. The second key rule in all of this is the hearing rule, and that is, in short, an affected person has a right to be heard and present their case. They should be afforded a reasonable opportunity to respond to the allegations made against them, and they should be given an opportunity to be heard. So this is a key point for investigators, particularly, that the purpose of a workplace investigation is a fact-finding mission. You want to hear both sides of the coin, so to speak. Same with the decision maker. They want to hear both sides. They don't just want to hear from the complainant and what the complainant says. They want to provide the opportunity to the subject of the allegations to hear what's said against them and to be able to respond. I've noticed there that there's a bit of flexibility and it depends on the case. It's perhaps beyond the scope of today, but that the obligation probably does change and over time and with increased seriousness. So contrast an initial approach to a subject officer. Some allegations have been made against you. We want to interview you and get your version of events. That's an opportunity. Obviously, there's given an opportunity to be heard, and they should know what the allegations are against them. Contrast that with a show cause notice at the end of the process. The investigation's been done, and somebody's about to be subject to disciplinary action, and they're given a show cause notice as to why their employment shouldn't be terminated, for example. You'd expect that there would be more meat on the bone. There'd be more of that material provided to them at that point. The third key rule is the evidence rule. Again, pretty self-explanatory, but decisions are made on identifiable and logical evidence. They're not based on speculation or suspicion. The evidence disclosed by one side, and this goes back to the hearing rule that I mentioned a moment ago, that the evidence disclosed by one side should be provided to the other. And written reasons for decisions is best practice. The decision to investigate and certainly the decision to impose a disciplinary sanction are both appealable to industrial relations commissions, etc., and they're judicially reviewable decisions. So having written reasons and justification for that decision is vitally important. So that's enough of the boring background and the law. I thought I'd try to give some practical tips and summarise that and apply it to some common questions that might be asked, particularly by the subject officer who is the subject of complaints or a complaint and a workplace investigation. So some of the questions might be, and you've probably seen these, a common question is, what are the allegations against me? Can I know what they are? Well, the hearing rule provides that there is an obligation on the employer to provide an outline of the allegations against a person before an interview. It's best practice to put those in writing, and I'll come to some templates and examples in a moment. I don't think there's an obligation to provide everything, to provide a copy of every single thing, but just a fair summary of the allegations, and it's best practice to include at the early stage the possible consequences. So if it's a disciplinary matter and it might lead to disciplinary action, then that should be noted. Another common question that might be asked is, well, who's made these allegations against me? Who's complaining about me? There's no obligation to provide details of the complainant, but it's sometimes unavoidable and can depend on the case. Obviously, if it's a small workplace, it's probably unavoidable. It's a complicated one. It kind of depends on the circumstances a little bit, but I just note there to be aware of or be mindful of the possible PID Act implications and including the protection from reprisal action that employers must take, and also Privacy Act implications. Another common question asked is, can I have a copy of the allegations that have been made against me? Well, I don't think the cases say that there's no obligation to provide a copy of everything before somebody is interviewed. In fairness, key documents, and as I said before, allegations should be put to a person beforehand so that they have an opportunity to obtain advice and prepare a response. And again, in the templates I'll show you in a moment, a written summary, or indeed in the show cause notice, it should require, or there should be a setting out of the allegations made against the person with sufficient time for them to be able to respond. Another common question that might be asked is, well, who's the investigator and who's the decision maker? Who's going to be deciding my fate? So an affected person, a subject officer, does have the right to know who will be investigating and deciding, and best practice is to put that in writing, advising the person, preferably in a letter, or, for example, in a letter when inviting the person to attend an interview, or in a show cause notice. And again, there's templates available that I'll show you in a moment. And that's the perfect time to flick to handy resources. And again, forgive me if you know this stuff, you've probably seen it, but there's a few legislative requirements there for those in the state government. There's the Public Service Act Section 190, which provides some guidance on it. For those in local government, there's some regulations setting out some broad guidance for these sorts of things, and essentially encapsulating those three sort of key procedural fairness rules I went through a moment ago. Corruption in Focus, as has been mentioned a few times today, is a guide issued by the CCC for dealing with corrupt conduct in the public service, and it includes some, as Marie mentioned before, it includes some templates and some examples. There's a few Public Service Commission directives. There's one on workplace investigations and discipline, and again, these are available from the Public Service Commission website, and they're pretty handy. They give some advice and some guidance on conducting workplace investigations and disciplinary proceedings. The one that I found particularly useful is this one here. That's issued by the Public Service Commission. It's called Managing Workplace Investigations, a practical guide for the Queensland public sector, and Marie mentioned that before as well. For state government entities, this is essential. This gives a good practical guide for dealing with allegations of inappropriate conduct in the workplace or poor performance, not just corrupt conduct that you're obliged to report to the CCC, but also disciplinary matters, code of conduct breaches and the like. It's a very useful resource when considering or undertaking a workplace investigation. Again, I mentioned it's available on the Public Service Commission's website. It includes some very good templates as well and some guidance, including some draft terms of reference for a workplace or an internal investigation. It's got an investigation report template, as has the Corruption in Focus. And there are some template letters which you'll see there. If you haven't seen them already, it's worthwhile grabbing them and having them available if you're asked to or you're involved in managing a workplace investigation. There's a couple of letters there, one to the subject officer, inviting them in for an interview, which deals with a lot of the things that I've discussed today, and it gives a very good start for a letter inviting the subject of a workplace investigation into an interview to address those allegations against them. It also has template letters to witnesses who are not subject officers. So I hope that's given you a bit of a summary, a bit of an overview. As I said at the outset, hopefully this is all very familiar to you, and hopefully those tips and the links that I've provided are you find useful. If you do have any further questions, of course, you can always get into contact with us here at the CCC.